Good morning.
Morning.
All right, I've got 9 o'clock. Let's go ahead and get started. Let me welcome you to an oral argument session here at the 5th District Court of Appeal. My name is John Harris, one of the judges on the court, and I'll be presiding over the argument today. I'm joined on today's panel by Judge Brian Lambert and Judge Meredith Sasso. One case on the docket today, it's Depositors Insurance versus Pasco Pinellas et al. The proceedings today are being recorded and live streamed on YouTube. Each side has 20 minutes for the argument. Appellant can reserve however much of that time you would like for a rebuttal. We'll go ahead and set aside 5 minutes, but if you want something other than that, please just let me know. If there are no questions, Appellant, you may proceed.
Thank you, Your Honor. My name is Hinda Klein. I'm here on behalf of depositors. I would prefer 7 minutes for rebuttal. Our argument is fairly straightforward. Now, this is a PIP case in which the trial court addressed the issue of emergency medical condition. Under the PIP statute, unless a medical provider makes an affirmative determination that the insured has suffered an emergency medical condition, the benefits are limited to $2,500. If there is an emergency medical condition, benefits up to $10,000 are available. In this case, the trial court found...
The trial court did find that there was an emergency medical condition found by a licensed provider here, correct?
Actually, what the trial court found was that based on the facts in the medical records, there was an emergency medical condition. No provider, no physician licensed under the appropriate statutes made that determination.
Was that determination challenged at all in your initial brief?
Yes, it was.
Okay, and point to me where in the initial brief you challenged that determination that there was an emergency medical condition as contemplated by the policy, rather than, and I see in issue 1 that you engage a lot in the policy construction argument. In other words, that, you know, that if there's a lack of a determination, but I don't see that your initial brief really engages with the trial court's determination that in this case, there was a determination by a licensed provider that there was an emergency medical condition.
Your Honor, I'm not sure that I can get to it right this second. I'll certainly address that on rebuttal, but I know that we raised the specific issue that not only wasn't there a physician determination of an emergency medical condition, but the records themselves showed no incidence of an emergency medical condition because they specifically said that Ms. McKinney walked into the emergency room. The record showed that she has no risk factors. Her pain was minimal. She wasn't bleeding. She was in no acute distress. The CT scan of her lumbar spine turned out to be unremarkable for acute abnormality, and that she was only given a muscle relaxant and sent home. So there was nothing in the description of Ms. McKinney's injury, if you will, that indicated an emergency medical condition as that is defined under both the policy and the PIP statute. And therefore, we do take issue, and I'm sure somewhere in this initial brief, we took issue with the fact that the trial court, essentially, she kept saying it's common sense. This is a 72-year-old in an emergency room. She was just in an accident and she got a CAT scan. That is what the trial court focused on in making the determination about an emergency medical condition. But more importantly, what the court did not understand or did not mention in her final order was that there are two parts to the statute and the policy, and the policy tracks the statute. The first section says benefits are limited to $2,500 only if benefits are available up to $10,000 only if a physician makes an affirmative finding of an emergency medical condition. And the second part, and this is the only part that the trial judge addressed, is medical benefits are limited to $2,500 if a provider determines that an injured person did not have an emergency medical condition. So the trial judge erred in focusing solely on that second portion of the amounts payable provision, which says that benefits are limited only if a person did not have an emergency medical condition according to a physician. The court just simply did not address the second half of the statute or the policy language. And in doing so, the court made an error of law. We think that that error of law is clearly reversible. It is contrary to the small amount of case law that there is construing this statute. And that case law says that unless a licensed provider makes the affirmative determination that there is an emergency medical condition, the benefits are limited to $2,500. The second ground that we raised in our brief as a point on appeal was that the court did not address our affirmative defense that the notice of intent and this lawsuit was premature because depositor had specifically requested from Florida Hospital information or a determination that in fact the insured suffered an emergency medical condition, and Florida Hospital never responded to either request. And it's black letter law, especially in this district, that Florida Hospital was not entitled to a summary judgment because it never addressed the affirmative defense that we had raised both in our pleadings and in our own cross motion for summary judgment. There's no dispute in this case that Florida Hospital failed to respond to our request for information under 627-7366B. And if there is no response to that request, the statute makes it clear that payment is not overdue. And if payment is not overdue, a notice of intent is premature, as is a lawsuit, because at its core, a lawsuit for PIP benefits is a lawsuit alleging a breach of contract. So in your
opinion, if we disagree with you on the merits of that affirmative defense, in other words, if we disagreed that the statute requires Florida Hospital to respond with a statement of emergency medical condition as opposed to just a condition, is that an alternative basis that this court could affirm on that narrow issue on? Or in your view, is the simple fact that they did not respond to the affirmative defense at all grounds for reversal?
I think the fact that they didn't respond to the affirmative defense at all is ground for reversal, absolutely, because even assuming for the sake of argument that the court was correct in determining that there was an emergency medical condition, that Florida Hospital still had the obligation to make some kind of response saying, we've already sent you the medical records. The emergency medical condition is X, Y, and Z in those records. Had they done just that, then at least they would have complied with the statute.
And what is your response to the argument that there was an amended complaint, there was no answer filed, and therefore there's no affirmative defenses in the record that they'd be required to respond to?
Well, first of all, as the court is aware, the amended complaint only added a premature and inchoate bad faith count. It did not otherwise change the single count that pre-existed it. And it's our position that under these unique circumstances, especially since the trial court said you don't have to answer the complaint until after the abatement is lifted, then those affirmative defenses were still viable. And in fact, as we pointed out in our reply brief, opposing counsel specifically addressed, he claimed that there was one affirmative defense when in fact there were two, but he did address it at the summary judgment hearing. He just did not address this particular affirmative defense. So I think that's elevating a technicality when in fact all the parties understood that the pleadings remained the same as they were before the premature bad faith count was pled. And so in the event that this court finds that there was an emergency condition, and we submit that if the court were to find that there was an emergency medical condition without an affirmative statement to that effect from a physician, then it would be in conflict with the 3rd, 4th DCAs on that exact point. And we would certainly request that the court certify that conflict. But in the event that the court were to find in favor of Florida Hospital on that point, it would still nevertheless have to reverse this summary judgment because Florida Hospital never addressed the affirmative defense that it did not respond to to depositors' request for additional information. I'd like to reserve the rest of my time for rebuttal.
All right, very good. Thank you. All right, let's hear from the appellee at this time if you're ready, sir.
Thank you, Your Honors, and may it please the court. My name is Doug Walker. I represent Florida Hospital Wesley Chapel in this appeal. I'd like to point out that just off the bat that as depositors pointed out, their appeal is pretty straightforward, and it's based on the DCA opinions and the federal appellate court opinion in Robbins and Med Center of the Palm Beaches and Garrido. Each one of those cases, however, interpreted what the court deemed to be an ambiguous statute. In this case, Ms. McKinney did not have a policy of insurance with the state of Florida, with the Florida legislature. She had a policy of insurance with depositors. And so the case law on this is clear, and it's cited in the answer brief that when determining the amount of coverage pursuant to an automobile insurance policy, it's the policy and not the statute that controls. So the trial court's position was not inconsistent with
Is there
Garrido.
anything in the record indicating when this policy was entered into or renewed?
The copy of the policy that I have indicates the date of loss was 2017. So it was effectively in effect November 27, 2017. The effective date was September 22nd, 2017. That being the case, and that was the basis of the trial court's analysis, that was the argument by plaintiff's counsel in the trial court. Plaintiff was aware of the 3rd and 4th DCA and argued to the trial court that this is a breach of contract. And when construing, if you look at Robbins and you look at Garrido and you look at Med Center of the Palm Beaches, each one of those cases found the statute to be ambiguous in circumstances where there's been no EMC determination either way. And then to resolve that ambiguity, each court looked to legislative intent. Judge Sicklin in the 4th DCA quoting Robbins, even going and looking at legislative history to resolve that ambiguity. At best, and let's get to the trial court's order, quite frankly, the trial court construing the policy of insurance to determine the amount of coverage, which is what the law requires. When you're determining the amount of coverage, you look at the policy controls, unless it violates the statute. And I don't think there's any dispute that this policy doesn't violate the PIP statute. It's plaintiff's position and Appellee's position that it actually provides more coverage than is required by the statute. Of course, the PIP statute being the minimum amount of coverage required by automobile insurers in the state of Florida.
If the PIP statute, though, has already been interpreted in a manner that clarifies that if there is no determination at all, then the $2,500 limit is the catch-all, wouldn't that be the party's understanding when they entered into a contract in 2017? There's no conflict in that interpretation at any level.
Correct. And well, I think the Rudderman case that's cited in the answer brief talks about the, parties entering into a contract are not supposed to know the niceties and the judicial interpretations of statutes. I think that they're limited to the plain language of the contract. And that's what the trial court found is that, and this contract, the statute was interpreted in the context of the statute. The contract must be interpreted in the context of the contract. And on the first page of the contract, the declarations page, the page we're all familiar with when we get our own insurance, says boldface, $10,000 full coverage. And elsewhere, and there's a premium paid for that. So that's the contract of insurance. And then throughout this policy, $10,000 maximum benefit is referenced over and over again. And all those references are cited in the initial brief. Then literally in the middle of the policy, page 12 of 25, there's this provision that says, well, actually, we'll only pay $2,500, but we'll only pay $2,500 if we receive a determination that you did not have an emergency medical condition. And the trial court,
I think that makes more sense if you look at that provision and you vacuum and you read it literally. But like you said, our job is to look at the policy as a whole. And so in the paragraph 1, it's paragraph 6, it's very clear. $10,000 only if a physician licensed under Chapter 458 or 459, et cetera. Paragraph 7, by contrast, omits that only and says if. So if we're looking at a reasonable interpretation, I'm struggling to see why either we read it as $2,500 as a catch-all, or we read it as there's this large class of claims that the parties didn't account for at all, which is when there's no determination. How is that a reasonable rating of the policy, in other words?
Sure. And I think to answer your question, we can look to the guidance from the 3rd and 4th ECAs and that found when that language, which it's not identical to the statute, it's close, but it's not identical. But when that language is silent as to when there's no determination either way as to an EMC determination, that language is therefore ambiguous. That was the argument made to the trial court, and the trial court disagreed and said, no, I think there's a clear and unambiguous condition precedent. But plaintiff's argument was, at best, for depositors, the 3rd and 4th DCAs have held that language, the absence of how much PIP benefits are available either way, to be ambiguous.
So if we define ambiguity as a, two equally reasonable readings, in other words, silence isn't necessarily creating ambiguity. It's when there's two equally reasonable readings of the same language. Clearly, very clearly, only if is the necessary precondition for getting the $10,000. So I guess, is it reasonable to reach the conclusion that the parties failed to account for a large class of claims where there's no determination, or would that be an absurd result in the interpretation of the contract?
No, Your Honor, and that's a good question. And I think, even expanding out, not reading those two provisions in isolation, reading the deck page, $10,000 in full coverage. And we're not asking for the full $10,000. We're just asking for benefits in excess of $2,500. So I think that's a bit of a nuance, but I think the case law is clear that interpreting ambiguities in a contract, especially an insurance contract, when there's two reasonable interpretations, one providing coverage, one limiting coverage, that the court is required to resolve that ambiguity in favor of coverage and to construe it against the drafter. And that's what the Eccles case says. That's what Geico versus.
Yeah, and there's also cases from our court suggesting that that's a rule of last resort, and that the necessary second step would be taking parole evidence. So do you think if this court did find that language to be ambiguous, it would be just reversing summary judgment for further proceedings? Or do you think we skip immediately to, well, we can't figure it out, so you get whatever you want?
No, and I think the trial court actually got it right. And the more I understand like I said, plaintiff's argument that it was ambiguous. Ms. McKinney did not draft this contract. and I understand the court's point, but throughout, the only mention of that $2,500 limitation is in a provision that contains a clear and unambiguous condition precedent. Everywhere else, and I understand the court's point about the provision preceding that says up to $10,000 only if there's been a determination either way. But there's no genuine issue of material fact that the insurance company in this case did not have the requisite condition precedent in order to limit her benefits to $2,500. And the trial court went further, and I think it's important to understand the context of this case too, especially in light of Garrido, which I believe was a chiropractor, and Med Center of the Palm Beaches, which is urgent care, that this was everything about this case, applying the statute as it is written to the facts of this case, as it's presented to the trial court and to this court, everything about this case screams emergency. As she went to the...
I completely disagree with that comment. I mean, it seems to me you're taking a position, if you go to an emergency room, i.e. that is an emergency medical condition, that's not reality. I'm sorry. I mean, I know we're talking to the context of summary judgment. This lady basically said, I didn't see a doctor. I had back pain. The records show minimal back pain. I don't know how you can then leap to this saying it screams to be an emergency medical condition. So you've lost me on that argument, if that's your strongest argument here. And the other question I guess I'm missing here, because I don't know, if you say the insurance policy and the statute are not completely, I guess, identical. Let's say the insurance company says, okay, I'm going to look at this statute. I'm going to draft my policy word for word with the PIP statute. And then we have a scenario where there is no definitive determination of an EMC. It seems you're taking your logic to the extreme. Every one of those scenarios would mean that the PIP benefits are up to $10,000 because, as you argued below, it was ambiguous. And then that's how you construe. Am I missing something in this train of thought here?
No, not necessarily. And it's just that the analysis to resolve, each one of those courts resolved the ambiguity in the statute. And I think what the appellate court said in the 3rd and 4th DCA is that, hey, insurance companies, you are free to draft a policy that defaults to $2,500 unless we have an EMC. I think that's what Garrido says in Palm Beach, that the statute.
But I mean, in those cases, those 3 cases, 3rd and 4th and the 11th Circuit, I mean, it was a suit on a breach of an insurance policy. I mean, obviously, they didn't just show up in court one day.
Sure.
So, I know they don't specifically talk about the policies per se, but I have a hard time believing that there are any real difference in the policy we're talking about today. So you espouse this, well-known principle of, construe the ambiguity against the drafter. If there's ambiguity, you favor coverage as opposed to not. That would seem to me an easy route for all these smart judges in the 3rd and the 4th and 11th Circuit to say, well, there's ambiguity. Look at this. There's ambiguity in the statute that carries over to the policy, therefore up to 10 grand, and wipe your hands of it, and that's the easy answer. And that seems to be your argument. That sounds like that was your argument below to the judge, saying it's ambiguous. So ambiguous, we win. Right?
And the argument was based on this particular policy language. As a trial court PIP attorney, I've seen different policy language on this issue. I say some that we will limit benefits according to the statute and cite specifically to the statute. This policy is this policy. The policy language not discussed in Garrido and Med Center of the Palm Beaches and in the Robbins case, the 11th Circuit case, I think the patient even conceded that she did not suffer from an EMC. So I think that's an important distinction from that federal case to the extent the court was considering that. But we're stuck with the language that depositors used in this case. And I think it is important to note the difference in statutory interpretation and contractual interpretation, and that the case law is clear. The Florida Supreme Court case law, the Geico versus virtual imaging, the Wright versus auto owners case, the Kingsway Amigo, all those cases say that just by referencing the PIP statute and just by saying we're going to pay according to the PIP statute is insufficient to put the insured on notice that we're going to limit coverage a certain way. And each one of those cases said it's the policy that controls and not the statute. So I think when you constrain yourself, which plaintiff argues is required when interpreting a contract, to the terms of the contract, I don't think depositors has drafted a contract that allows them to, quote, for lack of a better word, default to $2,500 in absence of an emergency medical condition. Could they have drafted a contract that allowed that? Possibly, and arguably, assumably yes, based on the fourth and fifth DCA, or fourth and third DCA case law that interpreted the floor, the minimum amount of coverage required. But again, in the context of this case, and it's raised in the answer brief, these are emergency, when you read the statute as a whole, and I think the third and fourth DCAs construed the statute in pari materia, and they did a nice job of reading, if EMC $10,000, if no EMC $2,500, and they read that. They didn't expand out to where in this case there's no dispute that subsection 4C of the same statute applies, and in that statute, and in that portion of the statute, it requires insurers to set aside $5,000 for payments of providers who are providing emergency services and care. So I think when you construe the statute as a whole, expand it outside of these two provisions, that it's clear the statute was never intended to limit emergency room, CT scan, this type of treatment rendered in an emergency room to $2,500. She had $6,300, give or take, in medical bills. The intent of the no-fault statute since 1970 something has been to be swift and virtually automatic payment regardless of fault in situations like this.
So if I'm in a car accident and I break my little finger, that's it. And I said, well, it's a Sunday morning and I want to get this addressed. And I go there and they take an x-ray, which would seem reasonable. And I said, well, it hurts, but I'm not going to die. But it's a Sunday, so I'm going to the emergency room, as many people go to the emergency room by default. All right, so do I, because I have had an x-ray and I have gone to an emergency room, have I now sustained an emergency medical condition because the hospital sends my medical records to the carrier? Or don't I have to actually give a doctor, in response to a request by the PIP insurer, to say, yes, Lambert suffered an emergency medical condition under this statute, under the terms of the policy, when he had his broken finger?
Sure. And I think the best place to start with that is the definition in the policy of emergency medical condition,
well,
which says it means
yes or no. I guess that's a yes, according to your answer. I take that as a yes.
Well, if it could, yes, because it's seriously. Your finger is a body part. That's how it's defined in the.
But then that goes back to my initial question. If you walk in the emergency room and somebody actually sees you, in your view, under the policy language here, that's an emergency medical condition. And there's no ifs, ands, or buts, I guess.
No, not necessarily. I think when you come in with a broken finger, that could arguably result in serious dysfunction to any bodily organ or part that as defined. If you come in with the sniffles, or and in those situations too, if we're going to talk, kind of pragmatically, there's a substantial likelihood we're not running into $2,500 in emergency room bills. Also,
really, going to the emergency room, it's not going to cost you $2,500 just walking in.
Well, if you're not getting a CT scan and X-rays and all that stuff for a broken finger, if you come in with a hangnail and a nurse triages you in the hallway and sends you home, I don't think
you'd agree a hangnail would probably not be an EMC, right?
I think you and I can agree on that, Your Honor.
There you go.
Can you address the alternative argument that?
Can you address the affirmative defense argument?
Sure, and I'm glad you brought that up, because the fourth DCA case written by Judge Sicklin on this issue talks about the EMC, and this is in the Med Center of the Palm Beaches, and it says let's start with the Shams case. It's also cited by depositors, the Shams versus Jacksonville.
Can you actually start with the procedural issue that this is reversible error solely because you did not respond? The argument that Florida Hospital did not respond to the affirmative defense merits aside.
Sure. So the order granting the motion for leave to amend the complaint deemed the amended complaint filed as the date of that order. As we sit here today, there's been no answer. If they were to move for judgment on the pleadings, or the pleadings under the rules, I don't think would be closed. So I don't think there's been, and the exception to that rule is if it's tried, by consent. And I think if a review of the transcript, that issue was not tried by consent in this case. Even so,
there was no order from the trial court that an amended answer in affirmative defenses be filed, right? Wasn't the order that they file an answer after abatement was lifted?
Sure. And I think, to the extent that order was drafted the way it was I think it was clear that it was deemed filed then. To the extent it was ambiguous as to which count needed to be responded to, as an abundance of caution, I think defendants should have. And I think it was just sit here today. Like I said, if they had moved for judgment on the pleadings on count one, I don't think the pleadings were closed pursuant to the rules.
This might be one of the most disingenuous arguments I've ever heard or seen in a brief. I mean, there was a 45-paragraph complaint that was filed. Depositors filed their answer and a couple of affirmative defenses. Your client then filed several pages of avoidance to those affirmative defenses. A year or two later, you're allowed to add a second count, but in the order, the judge says, we're going to leave count two abated or pending, and plaintiff shall file an amended answer once that abatement is lifted. You say in your brief here that depositors was not required to answer count two until the abatement is lifted. That's not what the order says at all. That's a misstatement of the order. How do you address that?
Sure, Your Honor. And I don't want to make a bunch of hay of an argument that I can tell you're not, and it's not my favorite argument, to be quite honest either. So, but I think the court addressed the substance of
I'm more
the sick
with the misstatement of the record than I am the argument itself.
Yes, Your Honor. I mean, to be frank, I just think the argument was made in order to preserve the issue for appeal. I don't think it's our main argument. I certainly don't think it's our best argument. I'm here arguing the arguments that were raised in the brief. And like I said, I'm under a minute. I would hope to, I don't think I'm changing your mind on this. So I would hope to not spend too much more time, but I'm happy to answer any questions that you have on that particular issue.
Use the rest of your time how you'd like.
Thank you, Your Honor. With regards to the 6B request, I think the Shands versus Jacksonville case, assuming it was, I think we're all on the same page, was properly preserved. The Shands case says 6B is limited to what 6B says, and that's documents indicating the insured's history, the condition of treatment. And then Judge Sicklin in the 4th DCA said, had that been provided to USAA, USAA could have made a determination of whether an EMC existed. In this case, we provided that. The trial court addressed it, said we provided the history, and depositors essentially did nothing with it. And with that, my time has expired.
All right. Thank you, Mr. Walker.
Thank you.
All right, Ms. Klein, just under 9 minutes.
Thank you, Judge. First, Judge Sasso, you had asked where in the initial brief we had taken issue with the trial court's recitation of the emergency medical condition. And the only reference that I see to it is on page 16 of our initial brief. We argued that the trial court's finding that because McKinney treated an emergency room, she necessarily had an emergency condition, ignores the statutory and contractual language.
That's the only reference that I saw to it too. And I think you would agree that the remaining paragraphs challenged the contractual interpretation issue rather than the trial court's determination that there was an emergency medical condition found by a licensed provider. Trial court goes on for 2 to 3 pages in its order, talking about the lack of necessity of magic words, whether or not this provider was a provider, whether or not it is permissible to reference medical records in order to determine whether the court can make that determination. And so my issue is that regardless of the merits of that, a principle on appeal is that issues not challenged are waived. So how is the failure to address that legal determination, factual determination, not a waiver in this instance?
It's not a waiver because our argument is and has always been that only a specified physician can make an emergency medical condition diagnosis. So taking issue with the trial court's personal determination based on the facts in the record that there was an emergency medical condition would sort of be inconsistent with our position, which has been consistent all along. Depositors is not an appropriate physician. The trial court is not an appropriate physician.
Yeah, I understand that argument. It was argued to the trial court, but the trial court obviously rejected that. And that analysis, that legal analysis that you're explaining now is not in the initial brief.
That is correct, Your Honor. Well, no, the analysis in our initial brief is all about only a physician can make that determination, and there was none here. And we consistently made that argument because that is what the statute and the policy require, so that we don't get in these situations.
Are you saying basically that there has to be, a doctor has to say, okay, we've got your request depositors there, and I declare as the doctor licensed under 459 that this was an emergency medical condition, that simply having medical records from the ER itself submitted in the record, that the trial judge can't make that determination on her own? Was that what your argument is now, or below, or both?
That is our argument, Your Honor.
I
And
guess I'm just struggling to see where that argument is made in the initial brief from a legal standpoint, other than just that kind of introductory sentence.
well, as I read our point one, it's all about whether or not there needs to be a physician determining emergency medical condition, not the trial court and not depositors. I think that's the entire thrust of this case. And for us to take issue with the trial court's interpretation of medical records would have been entirely inconsistent with our
No, it would have been
position. That's
inconsistent,
what we're
just your
trying to
argument that
avoid.
there's not a determination. In other words, the trial court found there wasn't a determination. It wouldn't be inconsistent to say the trial court erred in that determination. But anyway, go ahead.
The opposing counsel's argument on the ambiguity of the policy doesn't really make any sense in light of the fact that it's undisputed that the policy language here tracks verbatim the statute. So we have case law from the 11th Circuit, the 3rd, and the 4th District, all finding that the statute requires that there be an affirmative determination on the part of a physician that there was an emergency medical condition. And to make the argument then that even if you track the statute, then you have to actually phrase it differently in order for courts to interpret the policy just as it interprets the exact same language of the statute. We cited Allstate versus Fox in our brief. And while that case had to do with an incontestability clause in a life insurance policy, there's a footnote in there that says, forget the adage where there's an ambiguity in the policy, it has to be construed against the insurance company, where, as in that case, the language of a policy actually tracks the statute. If that language which is in the statute has been determined to mean one thing in the courts, it necessarily follows it has to mean the same thing when interpreting policy language, which is verbatim. With respect to opposing counsel's argument on 4C, which is the priority issue, first of all, we don't even get to reach that if this court finds, as I think it must, that there was no emergency medical condition in the records here. But if the court were to even consider it, it's clear on the merits that the bills in this case were paid in accordance with the required priority. And with that, if the court has...
I just have one quick question. Just whether I see in the motion for summary judgment that you argued that Florida Hospital was required to respond. I am looking for whether or not the issue is preserved that Florida Hospital just needed to respond to affirmative defenses. Do you have whether or not that, or where that issue is preserved at your fingertips?
It's in our motion for summary judgment. which we
Right.
had filed.
So the motion for summary judgment, that one just had the merits argument. In other words, that, and I'm looking at 242.
Right.
So if just the general issue that Florida Hospital is required to respond to the affirmative defenses and its, summary judgment was improper, that would also be contained within that motion?
Well, yes. Well, no, because honestly, Your Honor, we made our motion first.
Right.
So
So
there
I looked at the
wasn't-
response to their motion for summary judgment. I didn't see it there. I was just, if you don't have it at your fingertips, that's fine. I just wanted to.
no, I don't have it at my fingertips. It was kind of odd procedurally because both motions were set for hearing, but only the plaintiff's motion was actually heard. But, it was addressed at the summary judgment hearing. So if the court has no further questions, I thank you for your consideration.
All right, thank you both very much. Interesting, well argued case. Court is going to be adjourned.